It's on YouTube. It's live streaming. So this is my petition. It's largely. I still have to. What you have to do is if you pay the filing fee, you have to make 40 copies, and there's going to be an appendix too with some attachments. But so. Let's maybe go through the questions. That's pretty short.
Hey, Glenn, can I ask a quick question?
Sure.
What is the area, or however you say it, and what is its purpose for the context for everybody?
Sorry, say that again.
Can you hear me now?
Yeah.
I said, what is the writ, and what is its purpose and use for everybody's context?
What is a certiorari?
Yeah.
Okay, a certiorari is an extraordinary writ, one of several. Certiorari is to review. It basically means to review. And under the rules, it used to be that the way you went to the Supreme Court is a petition for a writ of error, but they changed that after Downs versus Bidwell in 1901, and it's now just petition for review. Certiorari means to review it. So then the Supreme Court can do anything they want. It says right in their rules that they can turn any case away they want. So this is a petition for writ of certiorari. These are the questions right here. And I am basically challenging the constitutionality of some stuff here. Is the 1871 Municipal Corporation and 12 Stat 419 unconstitutional violation of Article 1 and Amendment because it comes from what is now the Vatican? Is the minor estate an unconstitutional violation of Article 1 and Amendment because it's created by the Pope's owned and operated Crown of England and the Cestui Que Vie Act of 1666, and was the cause of the War of Independence as evidenced by the Declaration of Independence and the causes and necessities for taking up arms issued by the Continental Congress in 1775 and brought into America with a code of law for the District of Columbia in 1901 at 31 Stat 1432. Is the National Bar Foundation and all its subsidiaries in the various states an unconstitutional violation of Article 1 and Amendment because it's the Pope's private bar guild originating in the Pope's owned and operated city of London, claiming immunity under an International Organization Immunities Act of 1945. Is it unconstitutional violation of Article 1, Section 8, Clause 17 for the Pope's County of Montague Municipal Corporation operating under the Pope's canon ecclesiastical law to use the minor estate to convert the petitioner's land from the land of Texas into the foreign District of Columbia to justify their extortion and theft of the petitioner's land? Is it an unconstitutional violation of the Equal Protection Clause in Article 4, Section 2, Clause 1 for the Pope's Federal Bureau of Investigation Military Police to refuse to investigate felonies by the Pope's County of Montague Municipal Corporation, to assault the petitioner with the minor estate to justify the theft of the petitioner's land and their extortion racket to get fake money in support of their communist agenda to eliminate private property rights, and because the petitioner is a targeted individual as evidenced by the targetedjustice.com website? Is it an unconstitutional violation of the Equal Protection Clause in Article 4, Section 2, Clause 1 for the Pope's United States Attorney to prosecute the felonies? And that's basically the same as the first one, except instead it's the FBI, it's the U.S. Attorney. Is it another one here is the Pope's Controller, unconstitutional violation of the Equal Protection Clause, Article 4, Section 2, Clause 1, for the Pope's Controller of Texas to authorize the Pope County of Montague Municipal Corporation to assault the petitioner with the minor estate, to render by force the petitioner's land for taxation, to justify the petitioner's land and their extortion racket to get fake money in support of the communist agenda to eliminate private property rights, and because the petitioner is a targeted individual as evidenced by the targetedjustice.com website. And this is Secretary of the Treasury. Is it an unconstitutional violation of the Equal Protection Clause, Article 4, Section 2, Clause 1, for the Pope's Secretary of the Treasury to refuse to dissolve and liquidate the Pope's minor estate in spite of the fact that the petitioner said he failed to care what they did with the fake money? They can put it up the rectal orifice because it was created by fraud and deception and is satanic necromancy and is being used to enslave the petitioner. Those are the ones that I got right now. I'll probably think of some more now that I've done with my the petition. I could probably add in some more. So anyways, the bar, Article 1, Section 8, Clause 17. Oh, the bills of attainder. Right. So then I need to add in, is the legislative act of the lower court. Anyways, bills of attainder. And that'll give me the clue that I need. So we're going to go through this in this. This is the table of contents, and so summary of the case. The petitioner converted silver to land on the land of Texas in 2021 and stated in the face of the deed that the petitioner failed to be a U.S. citizen or cestui trust, a true copy of which is attached thereto in the appendix, all of which is incorporated herein by reference in its entirety. The Pope's County of Montague Ecclesiastical Municipal Corporation, under the direction of the Pope's Texas Controller, and in conspiracy with the Pope's private bar guild, rendered by force the petitioner's land, thereby converting the petitioner's land from the land of Texas to the Pope's owned and operated foreign district of Columbia under the Commerce Clause. The Pope's County of Montague Ecclesiastical Municipal Corporation proceeded to enslave the petitioner with their Vatican minor estate, 31 CFR 363.6, with their tax notices, tax liens, and threat letters. The petitioner served by registered mail at Catherine Phillips notice and demand to the ringleaders of the Pope's Ecclesiastical Municipal Corporation extortion racket, explaining that they were engaged in multiple felonies and that the petitioner failed to be a U.S. citizen or a cestui trust, and demanding that they produce a bona fide contract, a true copy of which is attached hereto in the appendix, all of which is incorporated herein by reference in its entirety. The Pope's County of Montague Ecclesiastical Municipal Corporation got the Pope's Texas private bar. See, I don't notice a lot of things till I go through and read it. Bar Guild members to file a tax suit in the Pope's 97th District Court before the Pope's bought and paid for clergy, Patricia Coleman Byers. The petitioner filed 78 criminal complaints into the case and sent them to the Pope's Federal Bureau of Investigation, and the Pope's United States Attorney and the weaponized Department of Justice ignored them, as well as Byers. The Pope's bought and paid for clerks masquerading as judges, clergy in the Pope's 97th District Court issued a bill of pains and penalties similar to a bill of attainder with their legislative act against the petitioner, the named individual, and assaulted the petitioner with the Pope's minor estate to justify the theft of the petitioner's land by the Pope's County of Montague and their private bar guild handlers, and enslaved the petitioners with their Vatican Jesuit handlers. And the thieves were in the process of selling the petitioner's land when, on the day of the sale, the petitioner set off their extortion with their Federal Reserve note commercial paper, fake money, that are only for use in the Pope's owned and operated foreign district of Columbia. And this is the Gold Reserve Act of 1934. As used in this act, term United States means government of the United States. Term currency of the United States means currency which is legal tender in the United States and includes United States notes and Federal Reserve notes. The petitioner has never in his life breached the peace, but the Pope's Federal Bureau of Investigation military police refused to investigate the felonies, and the Pope's United States Attorney refused to prosecute the felonies that the Pope's County of Montague Ecclesiastical Municipal Corporation and conspiracy of the Pope's private bar guild members had engaged in in support of their weaponized Department of Just Us and their communist handlers. The petitioners filed bar grievances against 98 members of the Pope's private bar guild, some more than once, and they were all dismissed as an inquiry. The petitioner appealed all of the dismissals to the Pope's Board of Disciplinary Appeals, and they got dismissed again. All this originated with the Pope's Ecclesiastical Municipal Corporation established by Congress that is now owned and operated by the Pope. The petitioner filed the lawsuit in the Fort Worth Federal Court, and they issued a findings, conclusions, and recommendations to the United States Magistrate Judge, which fails to be the required findings of fact and conclusions of law, which means it has nothing to do with facts or law, which means they're legislated from the bench, and it's a bill of pains and penalties, similar to a bill of attainder, and unconstitutional under Article 1, Section 9, Clause 3, and Article 1, Section 10, Clause 1. The petitioner filed an appeal, and it is in the U.S. Court of Appeals for the Fifth Circuit, case 25-10360. Statement of jurisdiction. Article 1, Section 1 of this Constitution for the United States of America says all legislative powers herein granted shall be vested in the Congress of the United States, which shall consist of a Senate and House of Representatives. And Article 1, Section 8, Clause 9 says to constitute tribunals inferior to the Supreme Court. And since this court was created by the Judiciary Act at 1 Stat 77, the one Supreme Court talked about in Article 1, Section 8, Clause 9, and Article 3 can only be talking about a common law court that existed prior to the Constitution, because this court is a legislative inferior court created under Article 1, Section 8, Clause 9. This petition for writ of certiorari is brought pursuant to Article 3 of the Constitution for the United States of America that provides, right there, Article 3, Section 1. This petition is brought as an emergency petition pursuant to Rule 11. This action should be a petition for writ of error, but your clerks insist on assaulting the petitioner with the Pope's District of Columbia Codes, rules, and regulations under color of law, which is objected to on or for the record. This action was brought in the lower courts because of an act of the United States Congress, because taxation of land originated with an act of Congress acting under executive authority 3 months after Lincoln ordered Congress to reconvene with Executive Order Number 1 on the 15th of April, 1861. At Chapter 45, approved August 5th, 1861, at 12 Stat 292, that has not been repealed or modified, and that provided for tax assessors and collectors at Section 9, 12 Stat 296. They're required to execute a bond as Section 10, as 12 Stat 296. They have an oath of office as Section 11, 12 Stat 297. Secretary of the Treasury to provide regulations at Section 12 at 12 Stat 297. A direct tax on lands and lots of ground at Section 13 at 12 Stat 297. A Board of Assessors at Section 25 at 12 Stat 300. Tax liens on Section 33 at 12 Stat 303. Every collector who shall be exercised to be guilty of any extortion or oppression under color of this act shall be liable at Section 43, 12 Stat 307, and the penalty for taking false oath, perjury of oath, at Section 47 and 12 Stat 308, and there shall be allowed full compensations for their services at commission, which means they get a piece of the action wherever they can steal, at Section 48 at 12 Stat 308. This is an emergency petition because this has national importance due to the fact that almost every city, town, county, state of the Union, and state in the Union are now operating the Pope's ecclesiastical municipal corporations and assaulting almost all of the people, if not all of the people, in this country with the Pope's with the Pope's unconstitutional minor estate. at 31 CFR 363.6, and the Pope's private bar guild, all of which evidence is evidenced by the weaponized courts that Trump is trying to get rid of with his weaponization working group in the Department of Justice. Constitutional and statutory issues involved. The 1871 Ecclesiastical Municipal Corporation created by Congress at 16 Stat 419 is an unconstitutional violation of Article 1 and Amendment. Congress shall make no law respecting the establishment of religion or prohibiting the free exercise thereof, because it is a law respecting the Pope and the Vatican and the Holy See, and also because they're busy subjecting the petitioner to the satanic religious ceremony with their fraud, deception, lies, idolatry, and necromancy, in violation of the petitioner's sincerely held Christian religious beliefs. The minor estate, 31 CFR 363.6, and I need to italicize that. Is unconstitutional because it was created by the Pope and is in violation of Article 1 and Amendment. The National Bar Foundation and all their subsidiaries are all unconstitutional violations of Article 1 and Amendment because their head office is located in the Pope's owned and operated ecclesiastical city-state called City of London, which means it's owned and operated by the Pope. The judgment of the 97th District Court, as well as the judgment of the Northern District of Texas, are each a bill of pains and penalties, which are prohibited under U.S. Constitution Article 1, Section 9, Clause 3, and Article 1, Section 10, Clause 1. They're bringing the District of Columbia outside a maximum of 10 miles square in violation of Article 1, Section 8, Clause 17, and they're giving aid and comfort to the enemy in a time of war in violation of Article 3, Section 3, Clause 1. Statement of the case. The petitioner is posterity. The petitioner's mother and father were joined in the state of holy matrimony at the time the petitioner was born to them, and all of his ancestors were joined in the state of holy matrimony as evidenced by the statement of original status and the affidavit of corporate denial, which was recorded with the Pinal County Recorder at fee number 2013 032373, and the pedigree charts that are attached thereto. That is now the unrebutted truth in public policy, which may be viewed at their website. And Will Livingston ratified this Constitution for the United States of America on behalf of New Jersey, 1787, is the appellant's fourth great uncle, which means the petitioner's posterity is found in the preamble, and the petitioner is entitled to right of blood, and right of blood cannot be destroyed by any civil law because all the laws of Congress and all the laws of Texas are civil laws. And that's Bouvier's Law Dictionary, 1856 edition, page 768. And this court is operating under power which is derived from the petitioner as posterity, and the maxim says the power which is derived cannot be greater than that from which it is derived. Bouvier's Law Dictionary, 1856 edition. Therefore, it's impossible for the petitioner to give the Pope's County of Montague or their private bar guild handlers or this court any authority over the petitioner, and the legislative inferior court of the Supreme Court of the United States agreed and said it's impossible to confer sovereignty which will extend over the petitioner. And that's McCullough versus Maryland. The sovereignty of a state extends to everything which exists by its own authority or is introduced by its permission. But does it extend to those means which are employed by Congress to carry into execution powers conferred on that body by the people of the United States? We think it demonstrable that it does not. Those powers are not given by the people of a single state. They're given by the people of the United States to a government whose laws made in pursuance of the Constitution are declared to be supreme. Consequently, the people of a single state cannot confer sovereignty which will extend over them. The petitioner is exempt from the Pope's County of Montague and the Pope's private bar guild, not because of any formal conception or obsolete theory, but on the logical and practical ground that there can be no legal right as against the authority that makes the law on which the right depends. And the petition requires this court to regulate their property under Article 4, Section 3, Clause 2. The Congress shall have power to dispose of and make all needful rules and regulations with respect to the territory or the property belonging to the United States, which is the supreme law of the land, anything in the constitutional laws of any state to the contrary notwithstanding, Article 6, Clause 2, And we, the people, failed to be U.S. citizens because the Pope's 14th Amendment U.S. citizen failed to exist when the Constitution was written. I'm going to step aside for a minute. I'll be right back. Okay, so the term citizens of the United States must be understood to intend those who were citizens of a state as such after the Union had commenced and the several states had assumed their sovereignties. Before this period, there was no citizens of the United States. The Pope's 14th Amendment U.S. citizen. The Pope's 14th Amendment U.S. citizen is a fiction of law. It might be correctly said there is no such thing as a citizen of the United States. A citizen of any one of the states of the Union is held to be and called a citizen of the United States, although technically and abstractly there is no such thing. And this is Public Law 100-418, August 23rd, 1988. As used in this section, the term United States business means a United States citizen. It's a corporation. The Pope's 14th Amendment U.S. citizen was created by what is now the Pope-owned and operated Congress under the Pope's canon law. The 14th Amendment referred to slavery. Consequently, the only persons embraced by its provisions for which Congress was authorized to legislate in the matter were those then in slavery. The term resident and citizen of the United States as distinguished from a citizen of one of the several states, in that the former is a special class of citizen created by Congress. And Congress can only create fictions. All citizens of the United States shall have the same right in every state and territory as is enjoyed by white citizens thereof to inherit, purchase, lease, sell, hold, convey real and personal property. And that's current 42 U.S.C. Section 1982. 3. Fictions of law. Fictions of law were invented by the Roman praetors under the ecclesiastical canon law for the Pope's ecclesiastical city-states, that is now the Vatican, under the pretense of doing equity. And this is Bouvier's Law Dictionary, 1856 edition. Fictions of law owe their origins to the legislative usurpations of the bench. The fake judge is a legislator when dealing with fictions of law, which means the fake judge's legislative act is a bill of attainder, because the bill of attainder is a legislative act that applies to named individuals to inflict punishment without a judicial trial. A bill of attainder, and that's U.S. versus Lovett. A bill of attainder is a special legislative act prescribing punishment without a trial for a specific person or group. So, me. Bill of Pains and Penalties, a legislative act, though similar to a bill of attainder, prescribes punishment less severe than capital punishment. So a bill of attainder is the death sentence. Because judges only hold office, excuse me, during good behavior, excuse me, and judges in bad behavior, which is fake judges, these judges are engaged in fraud upon the court. Derogating common law. When a superior court of general jurisdiction undertakes anything in derogation of common law, it becomes an inferior court of limited jurisdiction. It is familiar law that when a special statutory authority in derogation of common law is conferred on courts of general jurisdiction, Such a court of general jurisdiction becomes quad hoc, a court of inferior or limited jurisdiction. A court can be a court of general jurisdiction for some purposes and a court of limited jurisdiction for other purposes. When, therefore, a court of general jurisdiction proceeds under a special statute, it becomes a court of limited jurisdiction for a purpose of such proceeding. Ecclesiastical Roman canon law equals the Pope's clergy. The judges dealing with the Pope's minor estate, 31 CFR 363.6, are the Pope's clergy. Yet it was found difficult to set bounds to ecclesiastical ingenuity, that's papal ingenuity, for when they were driven out of all their former holes, they devised a new method of conveyance by which the lands were granted not to themselves directly, but to nominal fiefs, to the use of the religious houses, that's the Vatican, thus distinguishing between the possession and the use, and receiving the actual profit while a season of the land remained in the nominal fief, who was held by the courts of equity, then under the direction of the clergy, that's the Pope, to be bound in conscience to account to assistic use for the rents and emoluments of the estate. And it is to these inventions, that's taxes, and it is to these inventions that our practitioners are indebted for the introduction of uses, that's usufructs, and trusts, the foundation of modern conveyancing, and that's Tomlin's Law Dictionary, 1835 edition, volume 2, under the definition of mort main. So, they are the Pope's clergy, and engage in fraud upon the court, in conspiracy with the Pope's private bar guild members, working with the Pope's County of Montague Ecclesiastical Municipal Corporation, when they issue a bill of pains and penalties against the petitioner, the named individual, to be accomplices to the theft of the petitioner's land by using the Pope's ecclesiastical fiction of law, minor estates, sestique usufruct. The Pope's forced rendition. The Pope's County of Montague Ecclesiastical Municipal Corporation converted the petitioner's land from the land of Texas to the Pope's owned and operated foreign United States by rendering by force the petitioner's land, even though the Texas tax code originating after the Civil War, with an act defining what money and property is subject to taxation or exemption, and the mode of listing the same, August 21st, 1876. And it says the property of corporations now existing and may hereafter be created, and the property of all banks or banking companies now existing or may be hereafter created, and of all bankers. And it is for corporate-owned property in Section 4, the term person, whenever the use in this act or any other act regulating the assessment and collection of taxes shall be construed to include firm, company, or corporation, and requires cash or its equivalent for their taxes, which means Federal Reserve notes. Market value means the price of property would transfer for cash or its equivalent, as explained in the Catherine Phillips Notice and Demand that was served on the Pope's County of Montague, that shows taxable land is used for the production of income. Rendition, generally, a person shall render for taxation all tangible personal property used for the production of income. And rendition originated with Section 7 in the Act of the Legislature of 1876. Section 7, all property shall be listed or rendered in the following manner. First, every person of full age and sound mind being a resident of the state, which is corporate property, which means the petitioner land fails to qualify for rendition, as explained in the Notice and Demand that was served on the Pope's County of Montague, because income is corporate profits. And this is Eisner versus Macomber, and the emphasis is in the original. You don't see this too often, whereas there's bold and underlining. It becomes essential to distinguishing between what is and what is not income according to truth and substance without regard to form. Congress cannot, by any definition it may adopt, conclude the matter, since it cannot, by legislation, alter the Constitution from which it derives its power to legislate, and which within those limitations alone that power can be lawfully exercised. Income is derived from capital, the gain derived from capital, etc. Here we have the essential matter, not a gain accruing to capital, not a growth or increment of value in the investment, but a gain, a profit, something of exchangeable value severed from the capital, however invested or employed, and coming in, being derived, that is, received or drawn by the recipient for his separate use, benefit, and disposal. That is, income derived from property. Nothing else answers the description. And so it's corporate profits. The Pope's ecclesiastical city-states in Italy. After the collapse of the Roman Empire, the Pope was absolute monarch of a group of ecclesiastical city-states in the Italian peninsula. Roman or papal states stretch across the central part of the Italian peninsula in oblique direction from the Adriatic to the Mediterranean, between Tuscany, Modena, and Lombardy on the northwest, and Naples on the southeast. Area 17,822 square miles. Population in 1833, 2,742,000. Capital, Rome. Population 153,000. Government, an elective monarchy. The Pope, for the time being, the absolute sovereign, with the consulting assembly of cardinals. The Waterston Encyclopedia of Commerce and Mercantile Law. Rome is the capital of the Pope's territories. And of Italy, anciently the Milrus of the Roman Empire. And while with the law being Roman law, which was also called canon law, and ecclesiastical law, and municipal law, and civil law. The laws of the municipia are dependent city-states. Civil or municipal law is that which every sovereign kingdom or state has appropriated to itself. The appellation of municipal was originally confined to the laws of the municipia, or dependent states. Canon law is a collection of ecclesiastical rules in the form of the civil. And this is canon law, or body of canon law, a collection of ecclesiastical rules, definitions, constitutions taken from ancient councils, the writings of the fathers of the church, the ordinances of the popes. This law is modeled according to the form of the civil, contained in 3 particular volumes. Civil law, Roman civil law are convertible phrases meaning the same system of jurisprudence, more properly called municipal law. And civil or Roman law is also called canon law. The civil or Roman and canon law, though they are not perhaps deemed proper parts of our written law, have undoubtedly had the greatest influence in Scotland. The power exercised by our sovereigns and judges have been justified upon no other ground than that they were conformable to the civil and canon laws. And the Pope's ecclesiastical city-states were annexed to the Kingdom of Italy in the year 1870, a year before the Pope's 1871 ecclesiastical municipal corporation was enacted by Congress. King John gave the kingdoms to the Pope. In the year 1198, Cardinal Locarius was chosen Pope and took the name of Innocent III. In history of Italy, AD 1198, Cardinal Locarius is chosen Pope, takes the name of Innocent III. He receives allegiance from the prefect of Rome and requires homage from all in the ecclesiastical state. And in the year 1213, King John gave the kingdoms of England and Ireland to Pope Innocent III and agreed to rent them back for 1,000 marks sterling per year. And not long after this, by general excommunication of the king and people of several years, because they would not suffer an archbishop to be imposed upon them, King John was reduced to such straits that he surrendered his kingdoms to Pope Innocent III to receive them again and hold them of him under the rent of 1,000 marks. And that's Tomlin's Law Dictionary, 1835 edition, volume 2, under the definition of Pope. With the concessions of England to the Pope in the year 1213. We will establish a perpetual obligation and concession. We will establish that from the proper and special revenues of our aforesaid kingdoms, for all the service and customs which we ought to render for them, saving in many things the penny of St. Peter, the Roman Church shall receive yearly 1,000 marks sterling, namely at the feast of St. Michael 500 marks, and at Easter 500 marks, 700 namely for the Kingdom of England, and 300 for the Kingdom of Ireland. Which means the Pope owns the kingdoms of England and Ireland, now known as the United Kingdom, the Crown, and the City of London. The Pope's dependent city-state in the City of London called the Crown created the Cestui Act of 1666. Yet still it was found difficult to set bounds to ecclesiastical, that's papal, ingenuity, for when they were driven out of all their former holes, they had devised a new method of conveyance by which lands were granted not to themselves directly, but to nominal fiefs, to the use of the religious houses, that's the Vatican, thus distinguishing between the possession and the use and receiving the actual profits, while the season of the land remained in the nominal fief, who was held by the courts of equity, then under the direction of the clergy, the Pope, to be bound in conscience to account to assist use for the rents and emoluments of the estate. That's taxes, and it is to these inventions that our practitioners are indebted for the introduction of usufructs, and trusts, the foundation of modern conveyancing. Tomlin's Law Dictionary, 1835 edition, Volume 2, under the definition of mortmain. Who was held by the courts of equity, then under the direction of the clergy, the Pope, to be bound in conscience to account to assist use for the rents and emoluments of the estate, which means the Pope's clergy were the judges in the ecclesiastical municipal law courts, which is what precipitated the War of Independence, as evidenced by the cause of necessity for taking up arms issued by the Continental Congress in the year 1775. Statutes have been passed extending the courts of admiralty and vice-admiralty far beyond their ancient limits for depriving us of the accustomed and inestimable privilege of trial by jury in cases affecting both life and property, to supersede the course of common law and instead thereof to publish and order the use and exercise of the law martial, and for altering fundamentally the form of government established by charter. We saw the misery to which such despotism would reduce us. That's dictatorship, folks. And the organic law of the Declaration of Independence shows it was listed as the reason for declaring independence from the Pope's tyrant, the Crown of England. He's combined, I'll just read this part down here, because when they say he is combined with others to subject us to a jurisdiction foreign to our Constitution and unacknowledged by our laws, the others is talking about the Pope. And the foreign jurisdiction is the Pope's ecclesiastical Roman civil law. And the definitive Treaty of Peace of 1783 in the preamble, it says King George was Arch-Treasurer and Prince-Elector of the Holy Roman Empire, evidencing the Crown of England is owned and operated by the Pope, and the Arch-Treasurer and Prince-Elector of the Holy Roman Empire, he was authorized to make peace on behalf of the Pope, which is also why thousands of people were fleeing Europe at that time, because of the Pope's tyranny there, as talked about in John Locke's 2 Treatises of Government. And this treaty is the exercise of power beyond right. And the Spanish Inquisition. Inquisition is one way of proceeding in the ecclesiastical courts. I don't know if anybody's been to the Louvre. I went through the Louvre one time when I was in Paris, and there's a whole wing that's dedicated to the Spanish Inquisition. And there's lots of paintings with blood all over them, let me tell you. And other inquisitions and oppressions they routinely engaged in. The use of information has a long history. For example, in the reign of Henry VII, a very oppressive use was made of them for something more than a century so as to continually harass and shamefully enrich the Pope's crown. And that's Blackstone's Commentaries. Courts ecclesiastical, spiritual courts, are those courts which are held by the king's authority as the supreme governor of the church for matters which chiefly concern religion. And the laws and constitution whereby the Church of England is governed, much oppression having been exercised through the channel of these courts on persons charged with trifling offenses within their spiritual jurisdiction. Well, you don't see that happening today? I certainly do. It's also why the petitioner's ancestors made the very first article and amendment, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, because they did not want it happening here. Therefore, when they're talking about pretended legislation and pretended offenses in the Declaration of Independence, he's combined with others to subject us to a jurisdiction foreign to our Constitution, unacknowledged by our laws, giving his assent to their acts of pretended legislation, for transporting us beyond seas to be tried for pretended offenses, they're talking about the Pope's ecclesiastical Roman canon civil law. Canon law is the body of Roman ecclesiastical law relative to such matters as that church either has or pretends to have proper jurisdiction over. Canon law, body of canon law, collection of ecclesiastical rules, definitions, constitutions taken from ancient councils, the writings of the fathers of the church, ordinances of the popes. The law is modeled according to the form of the civil and contained in 3 particular volumes. And that's New World of Words, 1720. Phillips, The New World of Words. There are lots of references in these old law dictionaries to the Pope's pretended jurisdiction. Jesuits, born in the king's dominions and ordained by the pretended jurisdiction of Rome. The oath of supremacy is principally calculated as a renunciation of the Pope's pretended authority. The Pope's private bar guild. The Pope's clergy operate their ecclesiastical Roman civil law courts with a private bar guild, with bar being an acronym and stands for British Accredited Regency. Regency is the office or jurisdiction of a region or body of regents, a government or authority by regents, the period during which a region or body of regents governs. Because the Pope's private bar guild clergy members are appointed by the Inns of Court. Inns of Court, certain private unincorporated associations in the nature of collegiate houses located in London and invested with the exclusive privilege of calling men to the bar, which is located in the Pope's dependent city-state, located in the city of London, originally called the Kingdoms of England and Ireland, now called the United Kingdom, and the Crown since the concessions of England to the Pope, 1213, which means all private bar guild clergy members are foreign agents of the Pope, which while they're here under the Pope's civil laws of Congress, foundation of the Federal Bar Association, under the Code of Law for the Pope's District of Columbia, now known as Title 35, U.S. Code 70501 through 70512, claiming immunity under the International Organization Immunity Act of 1945, 59 Stat 669. Article 13, an amendment disappearance. There is reason to believe that the Pope's Crown of England orchestrated the War of 1812 to facilitate the disappearance of the true Article 13, an amendment, because one of the major engagements was when the Pope's owned and operated British Army went to the capital and burned the National Archives, which is where the ratification records would have been kept. The petitioner has seen the same Article 13, an amendment taken from Colorado statutes in the 1850s, and there's reason to believe that Lincoln might have used the Civil War to facilitate its disappearance, because Lincoln was one of the Pope's private bar guild members. And he would not be qualified to hold office with it in place. And there's a statue of Lincoln in the Pope's owned and operated city of London. I wonder what's up with that. The Pope in the Civil War. The Pope was involved in the Civil War because the Pope's owned and operated Crown of England sent fleets of ships to attack Washington, D.C. and San Francisco in support of the Southern Confederacy. But the Russians sent fleets of ships to blockade the area in support of Lincoln. The judges in the lower court are private bar guild members and is required by the Pope's civil laws of Congress, called the Code of Law for the District of Columbia, now known as Title 28, U.S. Code, Section 631. No individual may be appointed or reappointed to serve as a magistrate judge under this chapter unless he's been for at least 5 years a member in good standing of the bar of the highest court of the state, and have exposed themselves to be the Pope's clergy. No quorum in Congress, emergency and necessity equals emergency and necessity. In the year 1861, the southern states walked out of Congress, and Congress ceased to have a quorum and could not conduct business. And on 15th of April, 1861, under emergency and necessity with executive authority, with Executive Order Number 1 at 12 Stat 1258, Lincoln ordered Congress to reconvene. and everything has been under the Pope's executive authority ever since. The Supreme Court ruled in a case that Lincoln failed to like, and Lincoln sent troops to the Supreme Court, which resulted in Rule 45, which is in place to this day. Rule 45, all process of this court issues in the name of the President of the United States, which means there's really no separation of powers. And when Obama was trying to get Obamacare passed, the courts were calling it unconstitutional, and Obama came out and railed on the courts. And when it got to the Supreme Court, they fell right into line and did what they were told and approved Obamacare. The Pope's 1871 Ecclesiastical Municipal Corporation. The Pope's ecclesiastical city-states were annexed to the Kingdom of Italy in the year 1870, the year prior to Congress's 1871 Ecclesiastical Municipal Corporation. The formerly Republican leader in southern Italy, Giuseppe Garibaldi, made common cause with the House of Savoy to overthrow the Kingdom of the Two Sicilies, and the people voted in a plebiscite to join Sardinia to form the Kingdom of Italy in 1861. The Papal States and the city of Rome were annexed to the kingdom in 1870, completing the unification of Italy. This kingdom lasted until the aftermath of World War II, when the 1946 Italian institutional referendum ended the monarchy, and are now called Vatican City and the Holy See, and it continues to this day. This is the Lateran Pact, Article 4, 1929. Sovereignty and exclusive jurisdiction over Vatican City, which Italy recognizes as pertaining to the Holy See, forbid any intervention therein on the part of the Italian government, or that any authority other than that of the Holy See shall be there acknowledged. The Pope's ecclesiastical Roman canon law, Sestike Ius, was brought into the United States first with the Pope's 1871 Ecclesiastical Municipal Corporation, 16 Stat 419, because civil law, Roman law, municipal law are convertible phrases, and because municipal law was the law of the municipia, or dependent papal ecclesiastical city-states. The Pope's Sestike V Act of 1666 was brought into the United States with the Code of Law for the District of Columbia in 1901. Excuse me. An act to establish a code of law for the District of Columbia, the legal estate to be the Sestike Ius, at 1617 at 31 Stat 1432. The Pope's minor estate, Sestike Usufruct, is now codified at 31 CFR 363.6 and are unconstitutional because Article 1 of an amendment requires Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. And the Pope's necromancy, Sestike Usufruct, which is now called the minor estate, 31 CFR 363.6, is an entity because an entity includes the estate of a living person, such as an incompetent or a minor. And that's 31 CFR 363.6. And a minor can anyone over the age of 18 years who's failed to take control of the securities in the Treasury direct account. The term minor is also used to refer to an individual who has attained the age of 18 years but has not yet taken control of the securities contained in his or her minor account. The Pope's Sestike Ius, minor estate, 31 CFR 363.6, is a fiction of law which was invented by the Roman praetors under the pretense of doing equity and owe their origin to the legislative usurpations of the bench. And the Pope's fictions of law are necromancy and satanic. There shall not be found among you anyone that maketh his son or his daughter pass through the fire, or that useth divination, or observer of times, or an enchanter, or a witch, or a charmer, or a consulter with familiar spirits, or a wizard, or a necromancer. For all that do these things are an abomination unto the Lord, and because these abominations the Lord thy God doth drive them out from before thee. And puts you under the Commerce Clause, Article 1, Section 8, Clause 3, violating Article 1, Section 8, Clause 17. To exercise exclusive jurisdiction in all cases over whatsoever over such district not exceeding 10 miles square. Two national governments. There are two national governments, one under the Constitution with all its restrictions, the other to be maintained by Congress outside and independently of that instrument. and that's the dissenting opinion of Justice Marshall Harlan, Downs versus Bidwell. The Pope's quasi-contracts, they use fraud and deception to assault people with a quasi-contract, which is a fake contract. A subset in its origin an action of tort. Subset was soon transformed into an action of contract, becoming afterward a remedy where there was neither tort nor contract. Based at first upon an express promise, it was afterwards supported upon an implied promise and even upon a fictitious promise. Introduced as a special manifestation of action on the case, it soon acquired the dignity of a distinct form of action which superseded debt, became concurrent with the count, with case upon a bailment, a warranty, bills of exchange, and competed with equity in the case of essentially equitable quasi-contracts. Black's Law Dictionary, 8th edition. Both in Roman and English law, there are certain obligations which were not in truth contractual, but which the law treats as if they were. They're contractual in law, but not in fact, being the subject matter of a fictitious expansion of the sphere of contract. That's why they did a findings and conclusions, no finding of facts, because there's no facts related to it. He's making it up. They're contractual in law, but not in fact, being the subject matter of the fictitious extension of the sphere of contract to cover obligations which do not in reality fall within it, which requires the Pope's fiction of law, minor estate, U.S. citizen. Constructive quasi-contracts are based solely upon a fiction or a fiction of law. Because under the Commerce Clause, the boundaries of the Pope's District of Columbia and through their plenary power nationally covers those citizens, even one of the several states, as though the district expands for the purpose of regulating citizens wherever they go throughout the states of the Union. Which is why in the Kavanaugh hearings, when he was being interviewed for a Supreme Court appointment, they asked him, "Can we go after a U.S. citizen in Afghanistan?" And he said, "Yes, you can." And because plenary power is a dictatorship under the Pope's Roman civil law, plenary is full complete in the courts of admiralty and the English ecclesiastical, that's the Pope. Causes or suits in respect to different courses of proceedings are termed plenary or summary. Plenary, a plenary power or plenary authority is a complete and absolute power to take action on a particular issue with no limitations. Plenary power, complete power over a particular area with no limitations. The Pope's fraud upon the court. The judges in the lower courts are tyrants operating as bought and paid for administrative legislative clerks masquerading as judges. The Pope's clergy under the Pope's canon law of trusts and bad behavior and fraud upon the court, which are non-judicial proceedings, because whenever a statute is involved, the Pope's fake judge is actually a clerk masquerading as a judge as the Pope's clergy. When acting to enforce a statute and subsequent amendments to the present date, the judge in municipal court is acting as an administrative officer, not in a judicial capacity. Courts administering or enforcing statutes do not act judicially, but merely ministerially, but merely acts as an extension, as an agent of the involved agency, but only in a ministerial and not a discretionary capacity. It's the accepted rule, not in the state courts, but in the federal courts as well, that when a judge is enforcing administrative law, they're described as mere extensions of the administrative agency for superior reviewing purposes, as a ministerial clerk for an agency. Judges become involved in enforcement of mere statutes, civil or criminal in nature, and otherwise act as mere clerks of the involved agency, which means they're legislators, engaging in legislative acts against a petitioner, a named individual, by using the minor estate, which is a fiction of law, which was invented by the Roman praetors under the pretense of doing equity, and owe their origin to the legislative usurpations of the bench, which means Patricia Coleman Byers, fake judge of the Pope's 97th District Court, and Hal R. Ray, in conspiracy with Reed O'Connor, the fake judges in the Pope's United States District Court for the Northern District of Texas, acted as legislators and issued a bill of pains and penalties against the petitioner, which are prohibited under Article 1, Section 9, Clause 3, and Article 1, Section 10, Clause 1. And also Article 1, an amendment, which says Congress shall make no law respecting an establishment of religion, because it's from the Pope's Roman law, also known as canon law and ecclesiastical law, and they're also bringing the District of Columbia outside a maximum of 10 mile squares in violation of Article 1, Section 8, Clause 17. Like colonial days, they've imposed the Pope's martial law rule, which is why we took up arms in 1775. And I've already read this. With Roosevelt's New Deal, with a bankruptcy emergency, it's an established fact that the United States federal government's been dissolved by the Emergency Banking Act, March 9, 1933, 48 Stat 1, declared by President Roosevelt being bankrupt and insolvent, HJR 192, 73rd Congress in section, June 5, 1933, joint resolution to suspend the gold standard and abrogate the gold clause, dissolve the sovereign authority of the United States and the official capacities of all United States governmental offices, officers, and departments, and is further evidence that the United States federal government exists today in name only. Since March 9th, notice the date, same as the date on here. Since March 9, 1933, the United States has been in a state of declared national emergency. Under the powers delegated by these statutes, the President may seize property, organize and control the means of production, seize commodities, assign military forces abroad, institute martial law, seize and control all transportation and communication, regulate the operation of private enterprise, restrict travel, and in a plethora of particular ways, control the lives of all American citizens. The majority of the people of the United States have lived all their lives under emergency rule. For 40 years, freedoms and governmental procedures guaranteed by the Constitution have in varying degrees been abridged by laws brought into force by states of national emergency. And that's NRE U.S. Senate Report number 93-549, dated November 19, 1973. Martial law rule is the law of emergency and necessity. There's three kinds of martial law. Full martial law, when actually invaded by a foreign enemy or insurrection, troops put on the street. Martial law proper is the law of the armed forces. When a sergeant tells a private what to do, it's enforced by court-martial. Martial law rule, law of emergency and necessity, used during peace times, can go on indefinitely. And that's Ex parte Milligan, U.S. Supreme Court. It's taken from a book called Non-Ratification of the 14th Amendment by Judge H. Ellett of the Utah Supreme Court. Well, let's see what's going on YouTube. Wow. Nobody making comments. Okay. But there are some viewers. Wow. Maybe it's because it's so late, I suppose. Okay, well, we'll keep going. The Private Bar Guild is here to enforce the martial law rule for the Pope and the Pope's Bar Guild clergy. Members on the bench tell you I can do anything I want in this court. This is a war of the intrusion over the civil law and the common law. The court in Diamond v. Harris calls the civil law statutory law superior equity. And this is a quote from Diamond v. Harris. It's difficult to see how the courts of the state are to ignore the common law as a rule of decision when it's made so by statute and adopt the civil law, even though it had the merit of superior equity. In the meantime, civil law was the form of law imposed by the Roman Empire, which was largely, if not wholly, governed by martial law rule. Equity has always been understood to follow the law. To have superior equity is to turn things on their head. This is exactly what happens when martial law is imposed. If equity is a law, then it follows its own course rather than following the common law, thereby destroying the common law and leaving what's called equity in its place. And that's the non-ratification of the 14th Amendment by Judge H. Ellett of the Utah Supreme Court. Because normally equity follows common law, which is taken from the Holy Bible, but under the Pope's martial law, there is no common law because it's superseded and replaced. It's also talked about in the causes and necessities for taking up arms previously cited. Every system of law known to civilized society generated from or had as its component one of three well-known systems of ethics: pagan, Stoic, or Christian. The common law draws subsistence from the latter. Its roots go deep into that system. The Christian concept of right and wrong and justice motivates every rule of equity. It is the guide by which we dissolve domestic frictions and the rule by which all legal controversies are settled, which makes it satanic. And the Pope's Private Bar Guild clergy, Satanists, are using the Pope's ecclesiastical canon Roman civil law of capitis diminutio. Capitis diminutio maxima, use the maximum loss of status through the use of capitalization, the highest and most comprehensive loss of status. This occurred when a man's condition was changed from one of freedom to one of bondage when he became a slave. It swept away with it all rights of citizenship and all family rights. Under the Commerce Clause, Article 1, Section 8, Clause 3, to assault people with their penal action for breach of quasi-contract, a fake contract. Penal action is an action on a penal statute for action for recovery of penalty given by statute. When an action is founded entirely upon a statute, the only objective is to recover a penalty or forfeiture. Such action is a penal action. The words penal and penalty in their strict primary sense denote a punishment, whether corporal or pecuniary. Remember that word pecuniary. And enforced by the state for a crime or offense against its laws. The noun penalty is the divine forfeiture to be forfeited for non-compliance with an agreement. Gee, that sounds like a quasi-contract. The words forfeit and penalty are substantially synonymous, which is pecuniary punishment for non-compliance with an agreement, all tied to the Pope's ecclesiastical Roman canon civil law, or canon Roman civil law, with the Pope's quasi-contract ecclesiastical pecuniary cause. Pecuniary cause, such as arise either from the withholding of ecclesiastical dues or the doing of neglecting such act relating to the church, whereby some damage accrues to the plaintiff towards obtaining satisfaction for which he is permitted to institute a suit in the spiritual court. Such, for instance, are the subtracting and withholding of tithes from the parson or vicar, the non-payment of ecclesiastical dues to the clergy, as pensions, mortuaries, compositions, and the like. And that's Blackstone's Commentaries on the Laws of England, cited in Holt House A New Law Dictionary. To populate the Pope's prisons by selling people into slavery. He, the prisoner, has as a consequence of his crime not only forfeited his liberty for all his personal rights except those which the law and its humanity affords him. He is for the time being a slave of the state. The Pope's clergy are priests of Baal, and the lower so-called courts are subjecting the petitioner to the satanic religious ceremony with their fraud, lies, deception, necromancy, and idolatry in violation of Article 1 and Amendment that the Pope's Federal Bureau of Investigation refuses to investigate and the Pope's United States Attorney refuses to prosecute with their weaponized Department of Justice that should be renamed Department of Just Us, because they intend to engage in war crimes in violation of Article 3 of the Geneva Convention relative to the protection of civilians in the time of war of 1949 by taking reprisals against the petitioner for political beliefs and religious beliefs, evidencing that the Pope's owned and operated United States has no intention of prosecuting anyone for war crimes unless it happens to fall within their political agenda. Commuting equals paid off the Pope. Trump even paid off the Pope when he commuted Roger Stone's penance sentence. Now it's penance, which was changed into a sum of money to be applied to pious uses, which is usufructs. Penitentiary has meant a penitent, an ordainer of penances, a place for penitence. Anderson's Law Dictionary, 1889 edition, page 764. Penance is a punishment imposed for a crime by the ecclesiastical laws. It's an acknowledgement of the offense. Penance may be changed into a sum of money to be applied to pious uses called commuting. And that's book 3 and 4 of the Institutes from Koch. And that's Jacob A. New Law Dictionary. And because it is the administrative legislative proceedings under the Pope's ecclesiastical Roman civil law, there are more people in prison in Texas as a percentage of the population than there are in communist China or the Soviet Union or the worst dictatorship in history. If there were Christians here, the Pope's private bar-guild clergy Satanists selling people into slavery would get their necks stretched. If a man be found stealing any of his brethren of the children of Israel and maketh merchandise of him or selleth him, then that thief shall die. Thou shalt put evil away from among you. And the Innocence Project estimates that 60% of prisoners are innocent. But it's such good business for the Pope and their ecclesiastical Roman civil law so-called courts, which is one of the grievances in the Organic Declaration of Independence, 1776. He's plundered our seas, ravaged our coast, burned our town, and destroyed the lives of our people. And it's planned and orchestrated by the Pope. All of this has been planned and orchestrated by the Pope from the very beginning of this nation. Within 20 years, this country is going to rule the world. Kings and emperors will soon pass away, and the democracy of the United States will take their place. When the United States rules the world, the Catholic Church will rule the world. And that's Roman Catholic Archbishop James E. Quigley, Chicago Daily Tribune, May 5th, 1903. Because the Pope was responsible for the War of Independence, and the Pope is responsible for what is happening today. The Pope owns and operates the ecclesiastical 1871 municipal corporation. The Pope now owns and operates the bankrupt 1871 ecclesiastical municipal corporation, 16 Stat 419, because when any ecclesiastical municipal corporation goes bankrupt, it gets seized by the creditors, as evidenced by the Roman Achaean military staff that's carried in battle by all commands and planted on all conquered nations, that's sitting on the right side of the speaker's podium. See image below. There's that Roman Achaean military staff, that arrow right there, and these are two Roman fascias that we're going to talk about next. And the two Roman fascia, bundle of rods bound into a weapon, symbolizing under the rule of a single man, that are on the wall on each side of the speaker's podium of the U.S. House of Representatives, which is also why, as Speaker of the U.S. House of Representatives, Nancy Pelosi told the members, we can't read this bill until after we pass it, because she was taking instructions from her Jesuit handlers, all of which evidences that the fact that the 1871 Ecclesiastical Municipal Corporation is 16 Stat 419, currently operating in the District of Columbia as the Pope's dependent city-state, and the Vatican's Pope Francis recently issued an apostolic letter about jurisdiction of judicial authorities of Vatican city-state in criminal matters that talks about concurrent jurisdiction in other states, which means other papal states like the District of Columbia and the City of London, United Kingdom Crown. This is right in that apostolic letter. When the same matters are prosecuted in other states, the provisions in force in Vatican City-State on concurrent jurisdiction shall apply. And that's apostolic letter Mutu Proprio, entering into force on the 1st of September 2013. Which means the Pope's ecclesiastical canon law is brought into Texas with the Commerce Clause, Article 1, Section 8, Clause 3, and the Pope's minor estate, 31 CFR 363.6. Maybe I'll do this. And the Pope's minor estate, 31 CFR 363.6, fiction of law, and the Pope's fictitious quasi-contract. And the Vatican's Pope Francis came and addressed his owned and operated Congress on 24th of September 2015, and the Pope's satanic private bar guild clergy members are assaulting people like the petitioner with their ecclesiastical fiction of law minor estate, sestike usufruct, trust necromancy with presumptions of jurisdiction, presumptions of the office of trustee because of sestike usufruct minor estate, and presumptions of suretyship. The petitioner has served literally thousands of registered mail notice and demands in an effort to defeat those presumptions, which was why they've targeted the petitioner with their targetedjustice.com website agenda. Entitled to common law. As posterity, the petitioner is entitled to common law, not canon Roman law by right of blood, as described in Article 6, Clause 2 of this Constitution for the United States of America, the supreme law of the land. This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made which shall be made under authority of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the constitutional laws of any state to the contrary notwithstanding. And also is found in the Judiciary Act, saving suitors in all cases the right to a common law remedy, where a common law is competent to give it, and also have exclusive original jurisdiction, cognizance of all seizures on land and other waters, as aforesaid, made, and of all suits for penalties and forfeitures incurred under the laws of the United States. And that's 1 Stat 77. And the Judicial Code of 1911, third of all causes in admiralty jurisdiction, saving to suitors in all cases the right of a common law remedy where the common law is competent to give it. 36 Stat 1611 or 1161. And under Article 6, Clause 1, all debts contracted and engagement entered into before the adoption of this Constitution shall be as valid against the United States under this Constitution as under the Confederation. Because the Northwest Ordinance was adopted just 3 months prior to the Constitution, which defines the nature of jurisdiction in federal territory, and Section 14 of the Northwest Ordinance is hereby ordained and declared by the authority aforesaid that the following articles shall be considered as articles of compact between the original states and the people and states in said territory and forever remain unalterable unless by common consent to wit. And Article 2, the inhabitants of said territory shall always be entitled to the benefits of writ of habeas corpus and a trial by jury and the judicial proceedings according to the course of common law. No man shall be tried for his liberty or property but by the judgment of his peers or the law of the land, and should the public exigencies make it necessary for the common preservation to take any person's property or demand his particular services, full compensation shall be made for the same. Because law of the land phrase is a convertible phrase with the phrase common law. And this is American Jurisprudence, second edition, Constitutional Law, Section 543. The principle that no person shall be deprived of life, liberty, or property except by due process of law did not originate with the American system of constitutional law, but was contained in the Magna Carta, sometimes referred to as Chapter 29. Yeah, the Magna Carta was caused by the concessions of the Pope, where the Welsh barons didn't want to go along with the Roman law that the Pope was imposing on them, and so they stuck a sword to King John's throat, and they said, "Here, King, we want you to sign this." Confirmed on the 19th day of June, 1215, declared no freeman shall be taken or imprisoned or seized or outlawed or exiled or in any way destroyed, nor shall we go upon him nor send upon him, but by the lawful judgment of his peers or the law of the land. And has been said that the principle was known before Magna Carta and that it was originally designed to secure the subject against arbitrary action of the Crown and to place him under the protection of the law. It is settled beyond question that this principle came from England to America as part of the common law and has been a fundamental rule in common law. When first adopted in Magna Carta, the phrase law of the land had reference to the common law and has been a fundamental rule in the common law. And common law, the law of the land, has always been here long before the government was here. And the individual may stand upon his constitutional rights as a citizen. His rights are such as existed by the law of the land long antecedent to the organization of the state. Antecedent means before. Long before the organization of the state. And because the Pope's maritime codes only apply on the high seas and up to the high water mark or the first bridge of any navigable river, and the District of Columbia or any federal enclave, Article 1, Section 8, Clauses 17 and 18. The petitioner has been very vociferous about being posterity as found in the preamble, on a living man, a living soul, in every document filed into the case, evidencing the prejudgment on behalf of the Pope's private bar guild members on the bench, the Pope's clergy and their Vatican handlers, because it fails to matter what the petition says or does. This case was prejudged from the beginning using trust law by the Pope's clergy, because trusts are things and fail to have rights, and the Pope's clergy can do anything they want. The petitioner demanded the Pope's County of Montague produce a bona fide contract or be guilty of felonies in the Catherine Phillips Notice and Demand, a true copy of which is in the appendix, and they failed to produce any evidence of a bona fide contract or even answer. And the Pope's clergy in the lower court failed to produce a contract. It's impossible to prove jurisdiction exists absent a substantial nexus with the state, such as a voluntary subscription to license. All jurisdictional facts supporting the claim the supposed jurisdiction exists must appear on the record of the court. All courts are required to presume that no contract exists because none have been produced to this day. If the record does not show upon its face the facts necessary to give jurisdiction, they will be presumed not to have existed. The law requires proof of jurisdiction to appear on the record of the administrative agency and all administrative proceedings. The resolution of Congress says that because we have a Republican form of government, we're all sovereign citizens, as evidenced by House Joint Resolution 183, dated May 3rd, 1940, at 54 Stat 178, says in the preamble, it's desirable that our sovereign citizens of our nation be prepared for the responsibilities and impressed with the significance of their status in our self-governing republic. And as affirmed by Harold M. Stevens, Chief Judge of the U.S. Court of Appeals for the District of Columbia Circuit, in his article in the American Bar Association Journal, Volume 37, Number 4, April 1951, entitled Citizenship, the Real Profession of Every American. If our sovereign citizens are not informed upon such subjects, how can they intelligently participate in the determination of pertinent national policies? Which means the Pope's County and Montag ecclesiastical corporate ringleaders are engaged in treason to the Republic, as well as the Pope's clergy, Patricia Coleman Byers, Hal R. Ray, and Reed O'Connor, and the Pope private bar guild members giving aid and comfort to the enemy in a time of war because we were attacked by the communist Chinese, the Venezuelans, the Cubans, the Serbians, and others with the 2020 election theft and a fake pandemic and a forced medical experiment with their communist agenda to implement the first plank of the Communist Manifesto, the elimination of private property rights with their theft of the petitioner's land in this case. Roosevelt's New Deal was treason. Roosevelt's New Deal was treason because he declared bankruptcy within 3 days of taking office, and the bankruptcy abrogated the gold clause, no lawful money, HJR 192. Dated June 5th, 1933, and converted the United States over to the Pope, a foreign enemy that has been making war on us from the beginning. Making war on the Republic. The Pope's clergy, Patricia Coleman Byers, Hal R. Ray, Reed O'Connor, Pope's County and Montag Ecclesiastical Municipal Corporation, and the Pope's private bar guild members, as well as the Pope's weaponized Federal Bureau of Investigation, as well as the Pope's weaponized Department of Justice, and the Pope's Obama administration and the Pope's Biden administration are making war on we the people and the Republic, just like the Pope's crown did, which precipitated the War of Independence. He's abdicated government here by declaring us out of his protection and waging war against us. The Pope's clergy in the lower courts legislating from the bench. Hal R. Ray issued a findings, conclusions, and recommendations of the United States Magistrate Judge, and Reed O'Connor approved it, and they're required to issue a findings of facts and conclusions of law, which means it has nothing to do with facts or law, which means they are deliberately and calculatedly legislating from the bench with their bill of pains and penalties and expose themselves to be the Pope's clergy. A court can be a general court, can be a court of general jurisdiction for some purposes and a court of limited jurisdiction for other purposes. When, therefore, a court of general jurisdiction proceeds under a special statute, it becomes a court of limited jurisdiction for the purpose of such proceeding. That's Book 21 of Corpus Juris Secundum. Accordingly, where a court of general jurisdiction undertakes to carry out a special power, the decision made in the exercise of such power is treated as a ruling of a court of limited jurisdiction, and the presumptions applicable to a court of general jurisdiction that it acted within the scope of its jurisdiction does not apply. The Pope's clergy in the lower courts have presumed that the petitioner is a minor estate. The power to create presumptions is not a means of escape from constitutional restrictions. In spite of the fact that the petitioner says he's a living man and fails to be their sestike usufruct on everything, and has for many years. The Pope's clergy's bill of pains and penalties are unconstitutional acts and a nullity. An unconstitutional act is not law. It confers no rights. It imposes no duties. Affords no protection. It creates no office. Its illegal contemplation is inoperative as though it had never been passed. An unconstitutional law is void. It is as no law. An offense created by it is not a crime. No one is bound to obey an unconstitutional law. No courts are bound to enforce it. The Pope's clergy unfiled 78 criminal complaints. There we go. Which the petitioner filed into the case in support of the Pope's Federal Bureau of Investigation refusal to investigate them, in support of their targeted justice.com agenda and weaponized Department of Justice. Just us. To refuse to prosecute the felonies against targeted individuals like the petitioner, in the hope the petitioner will exercise his right to resist their unlawful arrest and their unlawful theft of the petitioner's land and their forced slavery with lethal force if necessary, so they'll have an excuse to murder the petitioner and say they killed another sovereign citizen terrorist in support of their war crimes agenda, to take reprisals against anyone who thinks they have rights for their political beliefs, and in support of their communist handlers to eliminate private property rights, all of which is in support of the Pope's private bar guild and their Vatican handlers who love satanic blood sacrifices to the Roman cult god Baal, so they can pillage the fake money from the Treasury Direct account under GlennWinningham Fern in all block capital letters, under the Hague Convention concerning the international administration of the estates of deceased persons, concluded 2nd of October 1973, and the petitioner is not suicidal, but if the petitioner does turn up dead, this is deathbed testimony, and the Pope loves the shedding of innocent blood. Therefore, whether they enslave the petitioner or kill the petitioner resisting their slavery, either way, it's a win-win-win scenario for the Pope. The Pope's clergy evidently intend to perjure their oaths of office to the supreme Lord of the land under the Pope's Code of Law for the District of Columbia, Pope's District of Columbia, as the Pope's United States Code 28 U.S.C. Section 453. Each justice or judge of the United States shall take the following oath or affirmation before performing the duties of his office. I do solemnly swear or affirm that I will administer justice without respect to persons and do equal right to the poor and to the rich, and I'll faithfully and impartially discharge and perform all the duties incumbent upon me under the constitutional laws of the United States, so help me God. And demonstrated they have no intention of being neutral or unbiased. It's a fundamental right of a party to have a neutral and detached judge preside over judicial proceedings. The petitioners filed bar grievances against 98 of the Pope's private bar guild clergy, some more than once, and they've all been dismissed as an inquiry. They were all appealed to the Pope's Board of Disciplinary Appeals, and they were all dismissed again. Complaints against the Pope's clergy. The petitioners filed judicial complaints against more than 50 of the Pope's clergy with the State Commission on Judicial Conduct, some more than once, and they've all been dismissed, 25 of them on the same day. Article 3 court only for life, liberty, or property. Only an Article 3 court can make decisions about life, liberty, or property. Justice Thomas, cases involving deprivation as transfers of life, liberty, or property constitute a court cases that must be resolved by Article 3 courts, not executive administrators dressed up as courts, which has been previously affirmed in numerous cases by the legislative inferior courts, where a controversy of such a character as to require the exercise of judicial power defined by Article 3 jurisdiction thereof can be conferred only on courts established in virtue of that article, and Congress is without power to vest that judicial power in any other judicial tribunal, or of course in an executive officer, administrative, or executive board, since they are incapable of receiving it. And that's Williams versus United States, 1933. Therefore, they're acting with no authority and maliciously. Although probable cause may not be inferred from malice, malice may be inferred from lack of probable cause. U.S. citizens equals Article 4, Section 3 court. And both the Pope's 97th District Court and the Pope's Northern District of Texas failed to be Article 3 courts, because 14th Amendment U.S. citizens Catherine Phillips and her County of Montague accomplices do not get an Article 3 court. We therefore decline to overrule the opinion of Chief Justice Marshall. We hold that the District of Columbia is not a state within Article 3. In other words, cases between the citizens of the district and those of the states were not included in the catalog of controversies over which Congress could give jurisdiction to the federal courts by virtue of Article 3. In other words, Congress has exclusive legislative jurisdiction over citizens of Washington District of Columbia, and through their plenary power nationally covers those citizens, even when in one of the several states, as though the district expands for the purpose of regulating citizens wherever they go throughout the states of the Union. That's National Mutual Insurance Company versus Tidewater Transfer Company. Evidencing that even though they're not possessing the power to abrogate the law, we're nevertheless willing to derogate from it under the pretense of doing equity, in support of their intent to be a legislature with their legislative usurpation of the bench, and their unconstitutional bill of pains and penalties because the Pope's County of Montague Ecclesiastical Municipal Corporation is in the Pope's owned and operated ecclesiastical municipal corporation called United States, which is operating in the Pope's District of Columbia under the Commerce Clause, and they're assaulting the petitioner with the Pope's minor estate. Article 4, Section 3, United States District Court is not a true United States court established under the U.S. Constitution, Article 3, to administer the judicial power of the United States, but was created by virtue of the sovereign congressional faculty granted under Article 4, Section 3, of making all needful rules and regulations respecting the territory belonging to the United States. Therefore, they fail to be an Article 3 court, but are instead under Article 4, Section 3, and they're not competent to make a ruling about the petitioner's life, liberty, or property, which includes land, and their decision is a void judgment, and the judges in the lower courts have exposed themselves to be the Pope's clergy, and the petitioner filed a notice of void judgment into the case, a true copy of which is attached hereto in the appendix, all of which is incorporated herein by reference in its entirety. Because the Pope's clergy in the lower courts love to find an excuse to ignore their oaths to the supreme law of the land, Article 6, Clause 2, the petitioner has been forced to file an affidavit of life and a mandatory judicial notice of 12 presumptions, true copies of which are attached hereto in the appendix, all of which are incorporated herein by reference in its entirety. But the petitioner doubts it will make any difference because they're the Pope's clergy and have no interest in justice, but are instead engaging in just us, for their Vatican handlers and our Satanists. You're of your father the devil, and the lusts of your father you will do. He abode not in the truth, because there's no truth in him. When he speaketh a lie, he speaketh of his own, for he's a liar and the father of it. John 8:44. But the fearful and unbelieving and abominable and murderers and whoremongers and sorcerers and idolaters and all liars shall have their part in the lake which burneth with fire and brimstone, which is the second death. Revelations 21:8. Conclusion. The Pope's 1871 Ecclesiastical Municipal Corporation, the 16 Stat 419, operating in the Pope's District of Columbia, is unconstitutional, as well as the Pope's minor estate and the Pope's private bar guild, because they're all violations of the Article 1 and Amendment, because Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, because there are laws respecting the Pope and the Vatican and the Holy See, and they're subjecting the petitioner and all of the people they're dealing with to their satanic religious ceremony with their fake court cases and with their fraud, deception, lies, necromancy, slavery, idolatry, and human trafficking. The findings, conclusions, and recommendations of the United States Magistrate Judge Hal R. Ray, in conspiracy with Reed O'Connor and Byers ruling in the 97th District Court, are each a bill of pains and penalties, a legislative usurpation of the bench against the named petitioner, and violations of Article 1, Section 9, Clause 3, and Article 1, Section 10, Clause 1, respectively. The Pope's County of Montague Ecclesiastical Municipal Corporation, in conspiracy with the Pope's Comptroller of the Texas and the Pope's Private Bar Guild in Texas and the Pope's Attorney with the rank of General, are bringing the District of Columbia outside a maximum of 10 miles square in violation of Article 1, Section 8, Clause 17. Signed and sealed in red ink on the land of Texas under penalties of perjury under the laws of the United States of America and without the Pope's United States Ecclesiastical Corporation. So anyways, I think I'm pretty well done with that. Does anybody have any questions?
Recording being the good, and also if you're referring to noticing Pope Pontifex.
I'm having trouble understanding what you're saying.
The mic off. I said,
You're kind of broken up. Plus, it sounds like I hear a foreign accent.
Hey, Glenn.
Yeah.
What would happen if you were to do a family use easement on the property where only your family of the family name, and that would clog the ability for them to step on to be trespassed.
Well, first of all, if you have absolute title to the land, there are no easements.
Right. That's not the issue,
So you're admitting that you don't have absolute title to the land by doing that.
Yeah. Okay. Never mind.
So I wouldn't. In a nutshell.
Easement on it.
said, would you notice Pope Pontifex? Because he's got the paper book.
Yeah, I'm still not understanding what you're saying there. I got pontificate or something like that, something about the Pope.
You said something about notice. Notice, have you noticed Pope Pontifex?
Pontifex, because he had branch of that Britain jurisdiction.
Yeah, it's kind of broken up. I'm still having trouble understanding what you're saying. Sorry, I don't mean to be disrespectful.
And sorry, it's probably back connected.
Too bad there's not a chat. Can you put it in the chat? Oh, there is a chat, actually. You could probably put it in the chat. I don't know how lengthy what you're trying to say is, but there's a chat. Anyways, what I'll do is I'll upload this stuff that I got right now. It's not finished, so I think the petition itself is pretty well done. I just have to, I gotta, there's other documents. I gotta do a table of authorities, and there's going to be probably a motion. I haven't, and there's an appendix too, and I probably will have to. So that a lot of that stuff is going to be subject to be getting changed, especially the appendix. If I add in documents, then I'll have to change the text of the petition to incorporate the documents. But anyways,
Isn't my question working now, Glenn?
yeah, you broke up.
Just speak a little slower, Andy.
He was just asking if my mic works okay now.
Okay, I got just asking if something about a credit card.
Andy, you seem to have a little feedback. Maybe whoever has their mic open could close.
Shut your mic off, Glenn.
One more time because it sounds like there's feedback.
Oh, Glenn, can you hear me now? I was asking if you noticed Pontifex, Pope Pontifex, as he's got the ecclesiastical thing from 1455, where they made the new lands, so to speak. They call them New Indias. You can find them in Civil, the inland port, and the papable 1455. And I just wondered if the recording had been a group at all.
Yeah, I went and turned off my mic and I got you good then. So, well, I put in the stuff that I need to show, my argument. I'm sure there's a lot of stuff, but I'm limited to 40 pages. Matter of fact, I had to scrunch it in big time, mess with it a lot to get it down to under 40 pages, and it's just barely under right now. And so, yeah, I'm limited to 40 pages, and so there's a lot of stuff I could probably add in. But I think I've got what I need basically to show that this is all coming from the Vatican, and that's the important part. There's might be even more than what needs to be there for that.
And if you, one sec, knock off your mic, Glenn. If you add that keyword on about to the king, like that thing he was on about, but if you add that 1455, where the only inland port and where Spanish called it New India, and where they took over because nobody claimed the land, and then they made that law for the Aboriginals. If you could add that there somewhere to express it, because that's where the machine of banking is, pertaining to your estates and whatever, your titles, rights, title and interest. If you go and have a look, it's all ladens a vessel and pertain to everybody's vessel. Just go and have a look. And it's like by survey as well, land.
I would just say that I don't dispute any of that. I believe it 100%. I mean, there's stuff about dumb diversus I could put in there. Again, I'm limited to 40 pages, and what I just need to show is that this right now I know that it's municipal law, and municipal law is Roman law. But what I needed to show was that Roman law is really ecclesiastical law. And which is and so that's why I put a lot of that stuff in there to show that's ecclesiastical city states, and that it's really ecclesiastical from the Pope, which means that it's definitely respecting an establishment of religion, and in that case it's definitely unconstitutional. I mean, there's lots of court cases that talk about an establishment of religion. The government's not supposed to be mixed up with religious organizations, and so I think I built a pretty good case. I don't dispute that kind of stuff went on. There's no doubt about it. But the important thing that I want to try and stress is that it's religious. That the Vatican is that the Roman law. These municipal corporations are really ecclesiastical law, and that's unconstitutional. They got no business, passing municipal law corporations. All of these municipal corporations need to be dissolved and liquidated.
Said about the king now, in 1455, King Henry VIII was the last illegitimate king. So if you prove he moved from king, like you said, the Magna Carta and the law, where Texas law derived from, it's Mike, Glenn.
I guess we'll see. Is there anything else? I think I'm going to wrap it up here because we've been going for over. It's about an hour and 40 minutes, and so and it's after midnight here, and so it's after 1 o'clock in the morning on the East Coast. So I think I'm going to wrap it up. I thank everybody. I thank Queen for letting me come in late and have something here, even though it's late. I was busy doing something else, and I didn't think I was actually going to make it. But when I got back earlier than I thought I would, I figured I'd see if it was possible. So I thank Queen for allowing me to do this, and we'll see you now next week. I'm going to be at the Extraordinary Science Conference, but I'm going to try and do this anyways. I'm going to try and do this. I'll be at the Extraordinary Science Conference in Albuquerque, New Mexico, and which means it'll be, let's see, it's 10 o'clock. It'll be 9 o'clock local time. Yeah, that should be no problem. That should be no problem. And so I'll be at the Extraordinary Science Conference next week. And that's going to be live streamed if anybody wants to watch the live stream, or if they can make it to Albuquerque, then that'd be even better. But we'll see you next week. I'm planning on being here next week. Same time, same place, same channel. So we'll see you guys then.
Night.
Glenn.
Have a good week. Travel safe, and we'll see you guys next week.
Glenn.
Safe journey.